right, we will go on the record now in the 13th Judicial District, the District Court of Greenwood, Kansas. This is case number 2023 TR3 00060, State of Kansas versus Curvin, and the defendant Isaiah Curvin appears in person and pro se. The trial is set for jury February 7 and 8. There is one count of operating a motor. Now that seems to the court to be you either had a license. Of course, the burden would be on the state to show there was no license, but Mr. Curvin, are you challenging that? Are you saying you did have a valid license?
No, I had a question before all that about the jurisdiction. I was challenging jurisdiction because I had a question about that.
Okay.
I wanted to know the cause and nature of what's bringing the suit against you. So I really didn't understand.
Right from the start, this isn't your average traffic hearing. It's a legal showdown brewing in real time. Kansas courtroom, a defiant defendant, and a judge who's about to test the limits of patience. Let's dive in.
Well, the people of Kansas, as you probably know, get together ever so often and have elections to elect people to represent them in Topeka, the state capital, and those legislators follow those laws. One of the laws at some point in time that those legislators made was that if we are going to operate a motor vehicle in Kansas, we have to have a driver's license when driving the automobile. It is to be treated as a Class B non-person misdemeanor, and they set the penalties of up to 6 months in the county jail and a $1,000 fine. So the authority comes misdemeanor. So does that help you with your question, sir, or is there something else we need to address?
Well, yes, I have another question. When you say it's been a criminal, would that gives the court two ways? The Sixth Amendment actually gives the court two ways to do it. They can do it through either common law or is it colorable maritime admiralty law? Which one am I want to be tried under with jurisdiction?
This is neither common law nor admiralty law. This is...
Here we go, the jurisdiction challenge. Classic sovereign citizen move. He's not answering the charge. He's challenging the court's power to even exist. Quick question for viewers. If you were the judge, how long would your patience last here? 5 minutes or 5 seconds?
Kansas, as affected by case law and federal law, of course.
So it's neither common nor color.
That is correct. That is correct.
So which one? What am I going to be tried under? What jurisdiction I fall under so I can properly move and so I can understand how to defend myself?
You're being tried under the criminal jurisdiction of the Kansas statutes.
But under and I guess it has two criminal matters. One has to be common law, the other has to be the maritime admiralty.
Ms. Gillette, do you wish to be heard in response?
Basically, kind of more of a statutory violation. This defendant, when you enter into the laws of Kansas, when you drive upon the highways, the interstate compact between all of the states that are members of the interstate compact for traffic infractions means that when you consent to the laws upon the roads of Kansas, Oklahoma, any of the states that are part of the compact, you consent to those laws when...
For those wondering, admiralty law has nothing to do with your driver's license. That's maritime law, as in ships and oceans. These myths float around online, but in real courtrooms.
By the Constitution of the state of Kansas and the laws of the legislature that are passed statutorily, and our statutes are this case. I would note for the record, Judge, that there is still no things on Odyssey for me to see. There's no motions to be heard today. I cannot respond to any motions because there's none on file.
Well,
therefore, if he is going to file anything of record, to have his filings on file at least 7 days advance of a hearing for me to respond. And that there is no proper written request for a jury trial at this. Or this case could go to bench trial on Wednesday, and we would not have to have a jury present due to the fact that there is no written request for jury trial. The case goes to bench trial.
Miss Gillette, we just had this exact issue on not filing a demand for jury trial in a Butler County case right before the lunch hour. Mr. Patterson presented 19 Canap 2nd 982, State of Kansas versus Gardner L. Jones III. Jones raised two issues on appeal, whether the district court abused its discretion by denying.
And here's where you see real legal strategy versus internet fiction. The judge isn't mocking him. He's citing actual precedent. But Isaiah isn't listening. This moment shows the difference between watching court clips on YouTube and actually understanding the law.
If you want me to entertain any of your arguments, you need to have them well thought out, and you need to have them in writing, and you need to have them, sir, listen to me, please. You need to have them in writing. You need to have court. You need to give copies and notice to Miss Gillette so she can have an opportunity to respond. And I'm not going to entertain this process throughout the proceedings where you come in and you just start things that you may have picked up here or there on the internet or by other people. I don't know where you get some of this stuff, but it is very common for people, certain individuals, to come in and start repeating some of this stuff. So far, I haven't heard anything that has merit. These arguments of, well, you're either maritime or you're common law. That's not going to carry weight with me. You're going to follow those arguments because I think you're misstating the law. So by now, you should have had all your motions on file. We're ready.
Maybe you misunderstood what I was asking.
Please don't interrupt to me.
I had a question.
Sir, stop and listen to me. If you want a jury trial, I will make sure you have a jury trial. If you want to represent, sir, stop interrupting me. If you want a jury trial, I will make sure you have a jury trial. If you want an attorney, I'll make sure you have an attorney to help you. But if you're going to do this on your own,
no, I'm not asking for legal advice. I'm asking for your legal intent. Trying to be which jurisdiction. That's why I'm asking if it's under which one. And you said it's a criminal matter. If it's criminal,
sir,
there's someone's been hurt. So if there's someone,
I have answered your question legally, and you keep trying to give me limited illegal choices. And
under the Sixth Amendment, I have the right to know. Under the Sixth Amendment, I have the right to know what jury I'm going to be tried against, and you have the duty to tell me. I don't think you're going to be violating your oath to office if you did that.
I've answered those questions, sir. Made it clear to you. It's a couple of hearings now that you're being tried in the District Court of Greenwood County, Kansas, under the laws of the state of.
This is the moment tension peaks. The judge tries reason, patience, even empathy, but you can almost hear years of courtroom experience sighing behind that robe. It's no longer about guilt or
on this.
That is not.
You know this, and I know this, and I feel like you're just kind of.
The Constitution only grants the court under when it comes to criminal under two matters, and that's why I asked you: is it civil? What you said is criminal. You said it's not civil, right?
Sir, you can reserve your right for appeal, but I have ruled. Now, what's your next question, or your next? And I need to have you back here. Bring your camera back so I can see you. I don't know if my phone froze or your did.
Oh, my phone froze. You cut out for a second.
Okay, so do you want an attorney? I'll ask you that again.
Before I get, I have the right. I have the Sixth Amendment right to know. If I ask, I have the right to know. I'm not. I'm asking.
I understand the sovereign citizen position that you take.
I'm not claiming. I didn't say anything about sovereign anything, ma'am. I'm asking.
You're sure making their arguments.
Under my Sixth Amendment right to know, I have right to know which jurisdiction are you going to try me under, and you're for you. And I'm like, before I even go to trial, I like to know what jurisdiction am I falling up under. And you're telling me in order to find out, I have to get a lawyer. So you're telling me they have to get a lawyer because there's already some way only lawyers understand what jurisdiction under. So that's the only way I can know. Instead of you asking me, but you have the duty to tell me under the Sixth Amendment, do you not?
Okay, now it's your turn to stop. I've answered your questions. I've told you the jurisdiction. You don't like my answers, so you voice your objection. We're not going to keep playing this game, sir. Now, do you want a lawyer or do you not?
I need a lawyer for you to tell me. When I'm asking you, like, because you said it's not in the criminal matter, so there's a hurt party.
Sir, quit repeating yourself.
If there's a hurt party, can you present the hurt party to me?
If you keep sitting here wanting to argue at the court, I may have to find you in contempt. Is that what you're trying to get me?
I'm not arguing about the court. I'm trying to understand.
I cannot educate you and train you.
I'm not asking for educate.
If you want to sir, do you know there's a person that's going to try to type out this transcript? And if you keep talking over me, do you know what chaos you're going to cause for that transcriptionist? We have to take turns talking. I've answered your question repeatedly. Let's move on to the next.
You better go back to law school. That's not just a burn. That's a legal reality check. The courtroom might look like a debate stage to Isaiah, but here, only one side makes the rules. What do you think? Was the judge too patient, or just right in holding the line? Drop your thoughts below.
Set for jury trial.
But before we even get to trial, man, you still haven't answered my questions. But I still want to know the cause of nature of the matter.
Sir, I'm going to find you in contempt. Respectful.
Ma'am, you keep not even answering my question before we get to jury trial. You're just setting it. You
are now found in contempt with your consequences Wednesday at the jury trial. This is set for jury trial. It's going to cost the taxpayers some money, so you better make sure you're ready to go to jury trial come Wednesday. You better make sure you're not in Texas courtroom in Greenwood County, Kansas. That's Eureka, Kansas. Do you understand, sir? Any questions about?
I still have questions that was never answered. I'm asking you, Judge, I'm asking for legal violation. Ask you what was your legal intent. You still haven't told me what you're going to ask you what was the cause of this.
My legal intent is to conduct a jury trial on you Wednesday with the jury.
And what was the nature and cause of this before all that? What was
the nature of this charge, operating a motor vehicle without a license in Greenwood County, Kansas, November 9th, 2023. That's the nature. Now,
and you said
we're not doing this.
I said when I asked you what jurisdiction, the Constitution grants the court the two jurisdictions. Which one is common law, and the other one is admiralty law. You said it's neither one of them.
Sir, you better go back to law school because I don't think you got the education you need to represent yourself. You either need to go back to law school or go to law school. So be ready to go. And if you're not here and ready to go, Wednesday, I will issue a warrant for your arrest.
Answer my question before you dismiss.
I told you, sir, I am not
under the Sixth Amendment, right? Under the Sixth Amendment, you have the
okay, I'm going to fine you. I'm only going to fine you $50 for that first contempt.
$50 for what?
For continuing to ask the same questions over and over after.
I'm asking it. You never answered it. You never told me what.
I'm going to object, Judge. We need to proceed to the next step. The state has taken the opportunity to glance through the case Mr. Patterson cited. It can be distinguished from this case because the ruling says the person has to be subjected to up to 12 months imprisonment. It is someone was convicted of a first-time DUI and they were subject to 12 months of prison time or jail time under the law.